Look, I'm not in the courtroom or some savvy lawyer, although I did study a bit of law. But here's the thing. There seems to be a real lack of consistency in our justice system. Here's ex-Labour MP Mike Amesbury punching a constituent to the floor. He was caught on camera, and it is definitely him. He pleaded guilty to common assault. He was initially jailed for 10 weeks after he admitted punching a man to the ground and then punching him a further 5 times whilst he was actually on the floor. Right, so if you're watching, you can see it. There was no evidence that he was provoked. Labour removed the whip, rightly. In October, Mike launched an appeal, and a judge said that whilst the length of the sentence has been spot on, it should be suspended for 2 years. So he didn't go to jail. Now, here is Labour councillor Ricky Jones calling for far-right protesters' throats to be cut. His exact words were, "They are disgusting Nazi fascists. We need to cut all their throats and get rid of them all." He said this in public on camera. After being accused of encouraging violent disorder after that video went viral, he was cleared at Snaresbrook Crown Court yesterday. And then there's Lucy Connolly, a 41-year-old Northampton childminder who was prompted by a rumour that an illegal immigrant was responsible for the murder of 3 girls at a dance workshop in Southport. Let's have a look at the tweet that she posted. She said, "Set fire to all the bleep hotels full of the bleeps on the day of a stabbing in Southport that left 3 young children dead. If that makes me racist, so be it." At the time, she had about 9,000 followers on X. Her message was reposted 940 times and viewed 310,000 times before she deleted it 3.5 hours later. Lucy was imprisoned for 31 months for inciting racial hatred and is due to be released in a few days' time, having served her entire jail time. Her appeal in May to be released sooner was quashed when 3 appeal court judges ruled that her 31-month sentence was not manifestly excessive. Does that make any sense to you? Let me get this straight. You can punch somebody as an MP, a position of power, on camera and have your sentence suspended. You can call for people's throats to be cut again on camera, but lest you tweet something which we all agree was not very nice, and in my view, no worse than calling for people's throats to be cut, you end up in jail for 2.5 years. Shadow Home Secretary Chris Philp said it was astonishing that a Labour councillor who was caught on video calling for throats to be slit is let off scot-free, whereas Lucy Connolly got 31 months in prison for posting something no worse. He went on to say, development of 2-tier justice is becoming increasingly alarming. Zia Youssef, the former Reform UK chairman, said the Labour councillor literally caught on video calling for people to slit the throats of the political opponents has been found not guilty. Meanwhile, Lucy Connolly gets 31 months in jail. 2-tier justice in this country is out of control. James Cleverly, the former Conservative Home Secretary, called it perverse. He wrote on X, "This is unacceptable. Perverse decisions like this are adding to the anger that people feel and amplifying the belief that there isn't a dispassionate criminal justice system." Ultimately, Mr Jones was found not guilty of the charge. The jury deliberated for over 30 minutes before reaching their verdict. But in my view, the Crown Prosecution Service is broken. There is no consistency whatsoever.
Using the internet without a VPN, a virtual private network, is a bit like taking to the road without car insurance. All it takes is one unlucky moment to cost you a lot of cash. This video's sponsor is Private Internet Access. They are the VPN to help keep you safe. Click the link in the description below to find out why over 30 million people have downloaded PIA to protect themselves online. A virtual private network is an app that hides your IP address and helps keep your data private. When you're browsing the internet at home, you give up a large amount of data to businesses, to shops, and indeed to social media giants too. Hackers have the ability to steal your personal data with ease, including sensitive information such as passwords, keystrokes, and even your personal photos. Private Internet Access helps protect your personal data by encrypting your internet connection to keep your data out of the hands of cyber criminals. And it's not just hackers either to be concerned about. Information can be censored too. When Canada passed their C18 bill, social media giants decided to ban news content on their platforms. But PIA can protect your ability to consume the news and content you love. Private internet access is available for Windows users, Mac OS, Android, Linux, iOS, and you can use one PIA subscription to protect an unlimited amount of devices. And we've got a huge GB News discount for you too. Click the link in this video's description and you'll get a massive 83% off PIA. That's under £2 a month, the price of a coffee, and you'll get an extra 4 months completely free on top. Also, there's a 30-day money-back guarantee too. Visit piavpn.com/GB News to start protecting yourself digitally today.
Well, I'm joined now by a former government lawyer, Amar Jahal. Amar, thank you very much for joining me. OK, so a lot of people are banding around the phrase two-tier justice. I like to call it complete inconsistency. It just makes no sense. Because in my view, I just think, well, if what one has done, that you have to balance out what is worse. And to me, all of the things were bad. So what are your thoughts? Where do you stand with it?
I thought that was a very interesting question you posed towards the end of whether the CPS is broken. There is a lot of commentary to the effect that everyone, the lawyers, the judges, the police, followed procedures in this case, and therefore morally the right thing has happened. I disagree, and I think you have to look back at the framework that treats things that appear to the public very similar in a completely different way, and also require the police and the CPS to take normative judgments about what sort of speech is acceptable and what isn't.
When you say normative judgments, what do you mean? I
mean, it's subjective. So historically in this country, you've been free to say what you want, provided it's not seditious against the Crown. Now, that has obviously receded as less relevant, or it doesn't libel or defame someone, or it doesn't incite violence. So it doesn't incite a crime. And that is normally what Ricky Jones was charged with, and Lucy Connolly was charged with the flavour of that, inciting racial hatred. Now, that requires, and the proliferation of similar criminal offences that require the police to determine what is offensive, what is harassment, requires subjective judgments. And I think even though in both cases the speech is unpalatable, the police shouldn't be in a position, the CPS shouldn't be in a position to decide what is palatable and what isn't.
I see. So in your view, what would you have done if you were the person prosecuting these people? What would you have done?
No, I think it's I'm trying to say it's difficult for the prosecutors in the case because they have guidance to follow. In particular, Lucy Connolly pled guilty, so that went sort of straight to sentencing, while as Ricky Jones's case, that went to trial and he was acquitted.
So he pleaded not guilty?
He pleaded not guilty, and this is, like I said, there are sort of technical and procedural things you can point to, and a lot of legal commentators are to say, well, the difference in outcome is justified, the difference in, potential sentence for these kinds of crimes is justified, but I would fundamentally disagree.
Because it's interesting that, you can plead not guilty but be seen on camera saying something that is clearly, just in my humble opinion, an incitement to violence. That's my opinion. Having seen that, if I was to shout for people's throats to be cut, I would be inciting people to do something violent. And I don't think that's that's a questionable supposition. But I'm just wondering how this can be that we have such disproportionate behaviour and disproportionate judgments. Whether one is right or wrong, in my view, they should have been dealt with in the same manner. Although I guess in this case, one pleaded guilty and one pleaded not guilty. So it was to work out whether the judge or those sentencing or looking at this case determined that Ricky was not guilty of inciting anything. And I guess he could then bring out mitigating factors that would make him say those things. Considered.
That's all spot on, Anna. So it's difficult with an inchoate offence, which is incitement. It's hooked onto another offence, which may or may not happen, and slitting the throats of the far-right protesters didn't happen in this case. So the question then the jury is considering, is it likely that he thought that would happen? And that's already difficult, but I would just sort of take you back in asking about whether there's a moral correctness and the public can consent to these differential outcomes. I would take you back to a legal framework which tries to protect different groups and say different groups require different levels of protection. If you believe in equality before the law, it should be that things that are fundamentally of the same substance carry fundamentally the same penalty. Wow. And that is the only basis I think the public can buy into the criminal justice system.
Thank you very much. That's really interesting and very insightful. Emma Johal, thank you very much. He's a former government lawyer. Thank you so much.
Thank you.
All right, well, 16 minutes after 4 o'clock. Joining us now to discuss this further is police and crime commentator and former advisor to Yvette Cooper, Danny Shaw. Danny, what are your thoughts on what Amar has just said?
Hi, Nana. Well, it's very interesting what Amar has just said. I mean, my view about this is that you weren't in the courtroom, I wasn't in the courtroom, Amar wasn't in the courtroom. And from my experience of being a reporter who has covered literally hundreds of criminal cases and trials, the people who know the evidence the best are the people who are in the courtroom listening to all of the evidence, not just snippets, not just watching clips, not just watching bits of CCTV or phone footage, but the people who are there at the beginning of the trial and at the end of the trial and hear all the evidence. And they are, apart from the barristers and the judge, obviously, they are the jurors, the 12 jurors. And it's very striking to me that when I have covered cases where I've actually been there for all of the evidence or virtually all of the evidence, and then you listen to people on the outside who just heard snippets, that you realise they have a completely different impression of what the case is about. They don't know, for understandable reasons, all the details, all the context and all the background. And that is why, in this case, I think you should respect the verdict of the jury. They reached a verdict after just half an hour, apparently, which suggests that they were pretty clear about what the decision was going to be. And that's why I don't think you can draw a parallel or draw comparisons between that case, the Ricky Jones case, and the Lucy Connolly case or the Mike Amesbury case. They're completely different cases in completely different contexts, completely different facts. And we don't know all the details about the Ricky Jones case because we weren't in court. That's not to say...
I did say that. I did say that at the beginning. I did say that at the beginning. But can I just stop you there? OK, so in what context would it be acceptable for me to say in public, on camera, to call for people's throats to be cut? I just want to hear how there is another context, because you're saying that I didn't hear all of it. I know I didn't. I said at the beginning I'm not there to hear all of it, but I'm just wondering, what context, then, would it be acceptable for me to say that out loud in public as a councillor?
It's not about whether it's acceptable. It's about whether it constituted a criminal offence of encouraging violent disorder to... Sorry, Nana. Go on. Whether it constituted a criminal offence of encouraging violent disorder to the high bar of, beyond reasonable doubt. That's the test. It's not whether it's acceptable. I don't think it's acceptable for anyone to do that, to make those sorts of remarks. But it's about whether it constitutes that criminal offence in that context. And the jury were unanimous that it did not reach that bar, and that's why he was acquitted. And so, Lucy Connolly pleaded guilty to a different offence in a different context. If she'd pleaded not guilty, she would have had a trial before a jury. Who knows what the outcome would have been then? But so they're different. So I think my own view is that for people to jump on the bandwagon of this case when we weren't in court and to suddenly say that this is an outrageous example of two-tier justice, I'm sorry, I'm misconceived. And I think you just have to take a step back and remember, you don't know all the facts. You weren't there, the jury were, and they reached their decision unanimously.
See, now, and the thing is, that's why I said at the very start that I wasn't there. I'm not a lawyer. But I think the problem here for Lucy Connolly was that she pleaded guilty, so she didn't have a jury. So therefore, there was no opportunity for someone to give her this kind of acquittal, which is kind of what's happened in this case, because perhaps the jury would have seen this as something that she shouldn't go to prison for. But I'm surprised that that would have been an option anyway, that prison would have been an option for that. But anyway, Danny Shaw, thank you very much. Really good to talk to you.